Mr. Bartman, good morning.
Good morning, Chief Justice Marshall, esteemed justices of the court. I am Frederick Bartman, and I represent appellant in this case. It was my argument in the brief submitted to the appeals court that a rational trier of fact could not find beyond a reasonable doubt that appellant was a sexually dangerous person. And the underlying issue...
But isn't that really a question for, the judge decides who to believe, and one person is enough.
That's true. And certainly courts in both SDP cases and criminal cases have said they're not going to disturb the assessment of credibility of the fact finder. But I think in the evolving law of interpretation of Chapter 123A, the issue that I sought to litigate in challenging the fact finder's determination is the weight to be accorded the opinion that's offered by the probable cause examiner at trial when that is indeed the chief Commonwealth witness and chief evidence.
Could you back up a little bit? And do you have an opinion whether the statute permits the probable cause expert to testify at trial?
Well, I don't think the statute specifically allows for that testimony, and I'll say it for this reason, that again, as I look at the statutory scheme itself has been said by this court and the appeals court to be the legislature's moniker of the kind of evidence that's going to be admissible, the procedure by which we're going to make this determination about whether or not somebody is a sexually dangerous person. So they very carefully and uniquely circumscribed what that evidence is going to be in terms of the admissibility of hearsay and things like police reports and other psychological records from the respondent's past.
Doesn't that last paragraph of Section 14 say, and any other evidence that bears on this, essentially?
It does.
As long as notice is given?
But to specifically answer Justice Cowen's question, I think that with regard to expert opinion, that within the statute they made very clear that the Commonwealth had the authority to interject the respondent's mental state into the litigation, that 2 qualified examiners would be appointed, that they are entitled to an examination of the respondent and obtaining of all of these records, and they are entitled by statute, the Commonwealth is entitled by statute, and frankly so is respondent, to call the qualified examiners to testify and for them to render a clinical assessment and an opinion. Also in that statute is the respondent's right to offer his expert and if indigent for the securing of funds to be able to do that. Nowhere in the statute is there a reference to a records-only reviewer and expert witness that can come on and offer a clinical assessment of how old records and some contemporary records and old behavior.
Then would you say that he or she isn't qualified to give an expert opinion because he or she has only examined records?
I think in essence that is the question, and that when you look at the statutory scheme in which, frankly, whether it's the initial SDP trial or in the Johnstone case just decided by the appeals court, a Section 9 review, that when you're looking at the present day mental state of the respondent, that there has to be expert testimony offered that makes a clinical connection between old behavior and the current mental state or prediction of behavior.
But you can do, that can be done, can it? In the Poisson case, we said that the Commonwealth they do not have the right to have an expert examine the defendant personally, but that doesn't necessarily preclude them from presenting an expert. And in fact, expert testimony is contemplated. So if they can hire any expert to come in, with the limitation that the person cannot be made to interview the defendant, they could hire any expert, including the probable cause expert.
I agree with that, and perhaps it's a red herring to be discussing this issue by way of using the term probable cause expert as opposed to any expert that the Commonwealth might seek to offer. And again, similarly to an NGI defense in a criminal trial or other proceeding where mental health is involved, you're going to have the right to offer expert testimony based simply on record review, but it is going to have limited value.
But that goes to the weight of it.
Yeah.
And you started by saying the question was what weight to give it.
Correct.
But that suggests, doesn't it, that it is admissible?
I didn't argue in my brief that it was not admissible. What I argued is that there, and especially when you look at the facts and the decision.
So it is admissible. You'll concede that?
I do,
Okay.
but not because he's the probable cause examiner or because the statute anoints him to some status that is the equivalent of the qualified examiners or the respondent's experts. And in fact, Justice Spiener, you asked, doesn't the Commonwealth have the right? The Poisson case said that the Commonwealth gets, without opposition, two qualified examiners that have the right to interview the respondent and obtain statements from the respondent and offer clinical assessments. And I think it was the Poisson case that went on to say, but they don't get their own independent examination. Mm-hmm. This is it. And it's this unique statutory scheme. And when you're assessing the sufficiency of the evidence, what I'm suggesting is lacking in the case law and in the way this judge analyzed the evidence is any distinction between the probable cause examiner and his opinion and the qualified examiners and the respondent's expert, and there should be. And that in particular, in this case, and I think really what should be in most cases, the probable cause examiner did not interview the respondent, and in contrast to qualified examiners and the respondent's expert that interviewed him on multiple times and interviewed other persons, and were able to link prior behavior and other evidence to his current, to the prediction of future behavior based on a current mental state.
Are you suggesting that although the statute doesn't impose such a sort of weight, how much weight to give, we should do that as a matter of policy, or?
Well, I think as a matter of clarification, because I see in this case certainly, and I don't want to go outside the record to other cases, but certainly in this case, what you see in this jury waived trial is the fact finder making no distinction in reviewing the evidence offered by the experts in this case. In a 14-page statement of findings, he basically reiterates in great detail the testimony of each expert and then says the Commonwealth met its burden of proof. Right. So we're left without knowing.
Well, it seemed to me that he also, though, explicitly gave great credence to Dr. Daniel, if I'm saying that correctly, and discounted Dr. Kiley, and I mean, he did make distinctions between. You may not agree with him, but he did make distinctions.
I agree, but he made that distinction. And Dr. Dagnall was the first witness called by the Commonwealth. It was an entire day of testimony, and it was the plurality amount of evidence that supported the judge's findings as he indicated them in his written material. And what I'm suggesting is that under the current state of the law and the rulings in this particular case and looking at all of the dialogue that went on between the court and the lawyers, where he continually indicated that he didn't know the science and he was going to be relying on the experts and so on, that there's no way of knowing if Judge McLaughlin made a distinction between the value of a records-only expert and the clinical assessments that are offered by statute, by mandate of the legislature. And Dr. Dagnall was so important to the Commonwealth's case, and in essence, what he offered was an opinion based on 15 to 20-year-old conduct and very callous letters. And
But
then
he also read and commented on I believe commented on, he certainly indicated he read the 2 QE reports.
well, that's true.
And what they had to say about their current conversations with the respondent, no?
But that almost begs the question of, well, how many experts are we going to have at the trial? If the Commonwealth, and again, this wasn't the record in this case, but what if both qualified examiners had rendered opinions favorable to the respondent, and the respondent's expert rendered an opinion favorable to the respondent?
I thought about that.
And the probable cause examiner reads all those reports and does a record review and opines to the contrary. I would almost say as a matter of law that that's going to be insufficient. And this is the standard I'm asking the judges to consider, that when it's a records-only review, you're not able to make the clinical assessment that is required by statutory mandate.
Craig, there's something a little peculiar, though, about the SDP, some of the theories behind what it is to be a sexually dangerous person. So if you do certain things or say certain things, they tend to have great weight or they tend to have little weight, depending on what it is. Some of the historical information, was your victim a victim of, was this a case of incest or you know, all those kinds of things. And as I read the judge's decision, he was placing considerable weight on some of these, you know, categorical factors, and they weighed very heavily against the defendant. Was there anything wrong with that?
No, I think that those static indicia are relevant. They're in play. The QEs rely on them, and a probable cause examiner or a records-only reviewer can offer his expertise. Where I think there is a disconnect is between the ability to recite the science and old data and connect that clinically to a current evaluation of the respondent's mental state.
Were there notes of you know, nurses and people at the facility that have been watching the defendant, you know, making observations, quote, current observations about his behavior and statements that he had been making?
I do not remember that.
Well, the letters were not, they were pretty recent, weren't they?
I'm sorry?
The 2 letters?
They were fairly contemporaneous with the evaluation, and certainly they're relevant and probative of his mental state. But standing alone, while obviously very bizarre thinking and bizarre behavior, not necessarily indicative of a likelihood of committing future sexual offenses and posing a danger to others, not to the extent that it would replace the clinical assessment that's required under the statute. And again, the judge is silent as to what drove his opinion. He gave a very detailed recitation of the Commonwealth's experts, said he found them to be completely credible, especially Dr. Dagnall. I think those were his words. And at the end said the Commonwealth met its burden of proof. And there were at least 3 different times during the Commonwealth's case in chief when Dr. Dagnall was asked to render an opinion as to whether or not the respondent was presently suffered from a mental abnormality such that it made him a risk of committing future offenses. They're on pages 73. 79 and 87 of volume 1 of the trial, and again, the trial judge makes accepts entirely and finds entirely credible Dr. Dagnall's opinion that Dr. Dagnall presently suffers from that mental abnormality or personality disorder. So it's inescapable that he relied heavily on it. It's inescapable that it was a large part of the Commonwealth's proof. And if the wrong standard is applied to a records-only reviewer, the danger is that it overcomes a vast amount of testimony from 3 other expert witnesses that are statutorily permissible and that have that opportunity to form a clinical assessment.
Are there any jurisdictions that have considered this question of whether an expert can even testify as to a person's present state without a recent personal examination, either in the context of sexually dangerous persons or in the context of a civil commitment?
Well, I saw Chief Justice Marshall nod affirmatively to that, so I'll say yes.
I think she was saying your time's up.
Yes, thank you. If there are no more further questions, I would rest on my brief.
Thank you, Mr. Barker.
Thank you.
Mr. Gold?
Thank you. Good morning, Your Honors. May it please the Court, David Gold for the Commonwealth. If I could pick up where my brother left off, I think it's important to note here that at the trial, the defendant never objected to Dr. Dano's testimony coming in. What he did object to was he objected to his report coming in. And I also think it's important to note that at the probable cause hearing, the defendant also had Dr. Plaud testify. At trial, Dr. Plaud also testified. So this is not a circumstance where the Commonwealth had one of its experts at the probable cause hearing who testified come in at trial and have the defendant have no opportunity to also have one of his experts who also testified at the probable cause hearing testify. I also want to point out that Dr. Dano did not simply repeat police reports or review historical facts. He did only a records review. But what he did was he also considered recent occurrences, and I believe the panel already discussed the letters that were sent. He also had the benefit of the qualified examiner's reports. And I think that that's important because the qualified examiners met with the defendant multiple times. I believe Dr. DeLisi met with him 3 times and Dr. Kiley twice, if I'm recalling correctly. So Dr. Dano did have the benefit of records of these interviews. And he was also able to form opinions based on those records. And in fact, you'll see in the judge's opinion, he discussed some of those. And he discussed the fact that Dr. Dano noted that the defendant was inconsistent when he was speaking of the crimes in which he was convicted to the qualified examiners. And that was one of the risk factors that he used to increase the risk that he was sexually dangerous. So I do think that while the statute does not explicitly provide that the Commonwealth can use the probable cause examiner, that at this point the normal rules of evidence need to come in. And at this point it's relevant, how probative it is. And in these circumstances, I think it's clear that the probable cause examiner's testimony was both. Also, there was also a qualified examiner who found the defendant sexually dangerous. So even without Dr. Dano's testimony, there was sufficient evidence for the trial judge to find the defendant sexually dangerous.
Do you have I know it's not this case, and I don't think that there's been a case where you, maybe there has, where you have the 2 qualified examiners saying the person isn't sexually dangerous, so and the Commonwealth puts on the probable cause expert.
Your Honor, I think that issue is still open, and I think this Court commented on it in the Poissant case, and that isn't this case.
I appreciate that.
But there isn't a case that actually explicitly says that in those circumstances the Commonwealth would not be able to, that the trial judge would not be able to find the defendant sexually dangerous.
There's another issue in this case, as I recall.
Find the defendant not sexually dangerous.
Excuse me?
Find the defendant not sexually.
To find him sexually dangerous.
Oh.
Yes, that in the circumstance that Justice Botsford was speaking of, that if the Commonwealth were to only have the probable cause expert, and both QEs said that he was not sexually dangerous, that the issue is left open whether or not that would be enough for the trial judge to find him sexually dangerous.
Okay.
There's another issue in this case relating to the admission into evidence of police reports. Is that correct? Police reports that documented many incidents of sexual abuse.
Yes, Your Honor.
Only a few of which were actually charged and ultimately pled guilty to.
Yes, but I would note, though, that while the defendant was originally charged with, I believe it was 40 counts of rape of a child in the district court, in the Superior Court he was indicted of 2 counts of rape of a child, but he also, it alleged on diverse dates. And in the police reports, which were admissible pursuant to 14C,
Well, that's the question, whether they were admissible as to everything in them or only those matters on which he was ultimately convicted.
and I believe this court addressed that issue in Given.
Yeah, in Given we did, but that really related to a police report about a sexual assault, and there were other things going on at the same time. I think that's a little different than a police report that relates to 20 sexual assaults over 4 years, only one of which is charged. Isn't that a different case?
Sure. I don't agree that it's necessarily a different case. I think the facts in Given were definitely different, but I think the court in Given, or if I believe the court in Given, also commented that by the defendant pleading guilty, at the time I believe it was in 87 or 89 that the defendant pled guilty to these crimes, there is some reliability, if you will, to those police reports. He pled guilty to the crimes, to the indictments, and there needs to be some underlying reliability just for this circumstances, so that 20 years from the offense, the defendant cannot come back and say, well, the police reports weren't exactly how.
Well, let's take, for example, a police report, and I haven't read them here, but it appears that the complainants here detailed a whole series of sexual offenses occurring over a substantial period of time. Let's say the Commonwealth reviews that and decides that some of the stuff just doesn't seem to be verifiable or doesn't hold up, but there are 1 or 2 that seem pretty strong, and so they indict on the 1 or 2, and they've made a judgment that the others really can't be proven. So that whole report comes in to evidence at a subsequent SDP trial?
Yes, Your Honor, it does come into evidence, and I think it's important to note that the experts did not just solely rely upon those police reports. While they're important in order to evaluate what the defendant has done in the past, that was not what they solely relied on. So they do come in.
You say they're coming in. They come in. The experts can rely on, but they're also independently coming in as evidence of sexual dangerousness. They're coming. The police reports are coming in independently, aren't they?
They're coming in also for the trial judge to consider, but they're coming in for the determination on, is he sexually dangerous today? And the past is definitely relevant to that consideration. And
I'm not suggesting it is. I'm just pondering whether Givens really covers this kind of case. You say it does.
Yes, Your Honor.
Okay.
And if the panel has no further questions, I'd be happy to rest on my brief.
Thank you, Mr. Gold.
Thank you.